When a company has been subjected to insolvency, directors are increasingly finding themselves being prosecuted for offences and behaviour they didn't know they were committing. So we're here to help you understand what it is you didn't know you were supposed to know. Kevin, I understand that the 2006 Companies Act was passed to make it easier for company directors to understand their duties. Has it worked?
Well, I'm not sure it has, Simon. I don't think it's the fault of the 2006 Act. The problem lies in the fact that anyone can become a company director without training or certification. So it's not really their fault either. But it does mean that many more companies find themselves struggling and in desperate need for some business recovery advice. And it's this point that 4R can provide invaluable help. So, for example, there are 7 general directors' duties, which are: act within the powers provided by the company. 2. Promote the success of the company. 3. Exercise independent judgment. 4. Avoid conflicts of interest. 5. Do not accept benefits from third parties. And 6. Declare any interest in proposed transactions or arrangements with the company. And number 7. Exercise reasonable care, skill and due diligence.
So what happens when a company becomes insolvent?
Well, when a company is in financial trouble, 2 things come into play. Firstly, the blame game. Stakeholders start pointing fingers, and everyone from staff, creditors, HMRC, other shareholders, etc., and even directors start blaming each other for the financial failure. You'll be surprised how even lifelong friends running a company together will turn on each other in those cases. And the second thing is probably more important. It's simply that when a company becomes insolvent, the legal requirements become much more stringent. You almost have to have a degree in the subject matter to understand the legal consequences of your conduct and actions.
Can you be a bit more specific?
Well, as I said, there's a lot of detail in this subject and I can't really cover it in a video. So my first advice is go to the webpage, download the FAQs on the subject and call the number on the screen now for further information. The challenge is to think about what is in the best interests of the creditors and stakeholders. So for example, if taking a bit more credit means a contract can be finished, it may be that invoices and the cash collected thereafter will be for the benefit of creditors.
So what's sensible isn't necessarily intuitive, because taking more debt on doesn't seem like an obvious solution.
That's right, and that's why we're here to help.
So what can be the consequences?
Well, the Insolvency Service, who are charged with investigating UK insolvencies, can look to recover HMRC debts from directors personally, lifting the veil of limited liability and arguing that the directors are personally liable as their conduct led directly to an HMRC loss. In addition, they can take legal action, and they seek a director's disqualification order and request the court to ban the individual from acting as a director for many years. This is also very damaging to an individual's wealth, their health and their future earnings, and you need to take it seriously.
Kevin, thanks very much. As we've just heard, there can be some serious consequences with HMRC debt. If you think you're at risk, or if you just need some friendly advice, please ring the number that's on the screen right now, because 4R Business Recovery are here and happy to help.